Next case on the docket is Griggs versus American Safety.
Yes, Your Honors, may it please the Court. My name is David Vukelja. I am the attorney for the appellants in this matter, Donald Griggs and 6 fellow Connecticut businessmen who are referred to throughout this litigation as the Connecticut Seven. This is the second time this matter has been before this court. Previously, my clients and I were here as the appellees in another appeal that had been brought by American Safety Insurance Company. The American Safety Insurance Group of companies are the appellees now. They were the defendants below. Specifically, the nature of this appeal is to question and order denying a motion for leave to amend entered by the trial court after remand by this court.
And after a trial, right? It came up first after a final judgment, correct?
Yes, sir. This matter proceeded to trial. Initially, there was a 4-count complaint that was part of the underlying proceedings. One of those counts fell by the wayside by summary judgment, proceeded to trial on 3 counts. 2 of those counts were dismissed by the court. Ultimately, it went to bench trial, started off as a jury trial. The trial judge determined that the count that was going to proceed, the unjust enrichment count, was an equitable claim. The judge dismissed the jury, proceeded to hear the matter himself. And after having heard all of that, entered judgment in the amount of approximately $3,500,000 for the Connecticut Seven on the unjust enrichment claim. That claim was appealed to this court. This court reversed that decision. This court reversed that decision for a number of reasons. It took issue with a finding of the court with regard to whether or not there truly was this ambush, if you will, that was testified to by one of the witnesses with regard to the presentation of new documents just prior to closing or new demands just prior to closing. The court also took issue with the damages that were awarded. The court determined that there was no competent substantial evidence. What the court also determined, what I would respectfully submit, which is essential to the matter that we're here on today, is the court found that the unjust enrichment claim failed as a matter of law. And that topic, that determination is first and foremost in this court's decision found on page 4 of its opinion. This court found that there were 2 theories, if you will, that the plaintiff had proceeded upon to trial. Number 1 was very specifically pled. The plaintiffs asserted that the $2.1 million that they had put into this project back in the mid-'80s constituted a benefit that was ultimately conferred or shared in by American Safety. If I might digress for just a moment, my clients put up $2.1 million to help the original developer get financing. Ultimately, that collateral that was put up was drawn down by the developer. Instead of this developer was organizing a massive project, and it ultimately took them 10 years to get all the development orders, permits, and what have you to build what is now known as the Harbor Village Golf and Yacht Club. The good news was the developer ultimately obtained all those permits. Bad news was the developer was broke by the time it had done so, and a mortgage holder by Citibank, who had ultimately assigned its mortgage to MD Marina, had started foreclosure proceedings. With that, the original developer looked for alternative financing and was introduced to the American Safety Insurance Company as a prospective lender. American Safety Insurance Company ended up entering into a loan commitment, then entered into a loan. Part of what's going to be important as far as this goes on is just prior to making that loan to the original developer, American Safety discovered that my clients held collateral as security, if you will, that they either wanted or needed to perfect their interests. Specifically, my clients, like I said years earlier, had put money up, but they couldn't get a mortgage to secure. So what they got was what I call a hodgepodge of security. They got stock assigned to them, or stock for them to hold. They got list pendants that were agreed to. So there were things, if you will, that they had and that were recorded that put everyone on notice of my client's interest. Well, in order for American Safety to go forward with its loan, it wanted the security my clients had. And with that, American Safety then itself brokered, if you will, an agreement between my clients and the owner, this Mr. McMurray. And they put the agreement together. It was called a profit participation agreement, and this agreement spelled out how my clients were going to get paid when the project was ultimately completed. And what's also important is this agreement very specifically says that American Safety would not get into this transaction if this profit participation agreement were not entered into. And what is also important is American Safety specifically said that American Safety would settle the pending foreclosure suit, which was the biggest threat to my clients having any opportunity to recover their monies at that point in time. Now, there's no agreement before the lower court, and it was never disputed on appeal that my clients complied and did everything that was requested of them. They delivered their security, they delivered their promissory notes, they canceled their list pendants, they agreed not to record the profit participation agreement, they agreed not to interfere in any way whatsoever. With that, my clients are done. What happens then is American Safety then proceeds to close with the owner. And when they close with the owner, what's discovered then is the foreclosure suit, unbeknownst to my clients who are already done and gone, the foreclosure suit is not settled. American Safety presents the owner with a settlement agreement, and what that does is American Safety is now going to step into the shoes of the plaintiff in the foreclosure action, and the owner is going to be stripped of all defenses, all counterclaims. And in fact, there's even an ex parte final judgment of foreclosure that's ultimately agreed upon as part of this package that's presented to the owner. Shortly after that, the owner is effectively replaced by American Safety. These are findings that are in the lower court's judgment that were never disputed. The American Safety basically takes over management and control of the project until ultimately it forecloses on McMurray. He's out. American Safety goes on to finish the project, and it's profitable. When my clients aren't paid as condominiums are being sold, they put American Safety on notice of their claim that they expect to be paid. American Safety disputes any obligation. And with that, in this piece of complex commercial litigation, the plaintiffs filed their suit, their four-count complaint. One was for count one, I believe, was on a third-party beneficiary. American Safety had entered into yet another profit participation agreement with the owner that made mention of the profits of the project being used to pay my clients. That was one of the counts. We also brought a count for constructive trust, the count for unjust enrichment, and a count for, I believe it's called enterprise liability. Within the plea, now specifically with regard to the unjust enrichment claim, which is the claim that we ultimately went to trial on, the count for unjust enrichment very specifically says that the benefit conferred is the investment my clients put in and the benefits, if you will, that created. And admittedly, that was done years before American Safety came on the scene. I'm going to estimate it was about 8 or 9 years between my clients putting their money into this project and American Safety involving itself. What was also pled in the complaint were allegations to the effect that they had also relinquished their security and their promissory notes and their list pendants in exchange for the agreement that the pending foreclosure action would be settled, but that in fact it was not. Now that wasn't specifically alleged in the unjust enrichment count. That was incorporated by reference. In any event, the matter, we proceed. Judge Walsh enters judgment. $3.5 million for the Connecticut group. It is appealed. This court determines because the Connecticut Seven's claim for unjust enrichment failed as a matter of law and the damage award was unsupported by substantial competent evidence, we reverse. Now this court, in going through the analysis of the unjust enrichment, first off pointed out that notwithstanding whether or not there may be deserving parties, that's not the telling feature, if you will. An unjust enrichment claim was an action at law, and one of the elements that had to be satisfied was to be able to allege and prove benefits conferred directly upon the party that you would hold unjustly enriched, and then prove that there were inequitable circumstances that made it unjustified that they should retain that benefit. We had specifically alleged the investment. This court determined that was not sufficient and found as a matter of law that that investment some 8 or 9 years prior to American Safety's involvement could not qualify as the type of benefits to be conferred to sustain an unjust enrichment claim. The court also went on to comment upon what it called the unpled theory. Judge Walsh in his order had determined that, and first off let me emphasize, there was no dispute at trial with regard to my client's investment.
What was appealed the first time around was the final judgment, correct?
Yes, sir.
It wasn't an earlier motion to dismiss that should have been granted that wasn't one of the issues. It was the final judgment after trial, correct?
Right, there were no motions to dismiss filed. The initial pleadings weren't challenged by American Safety until a motion for summary judgment was filed. At that point in time, the motion for summary judgment was denied, and motion for reconsideration of that was denied. So on appeal, this court determines that, like I said, the initial investment, as specifically included in this count, did not suffice. Court also determined that Judge Walsh's determination that my clients relinquishing their security conferred a benefit. This court determined or called that the unpled theory because it wasn't specifically set forth in the unjust enrichment count. It was incorporated by reference. In any event, the court found that that didn't qualify either because that was a benefit, if you will, that was paid for by American Safety as part of the transaction that it entered into with the owner. So the long and the short of it is, the outcome from this proceeding is it's determined as a matter of law that we never had a claim for unjust enrichment. There was no dispute regarding the proof. The proof was there as far as the contributions. The proof was there as far as the delivery of the security. This court determined as a matter of law, all the way from the pleadings through the entire process, that we never had a claim for unjust enrichment. And with that, it was reversed. Court also determined there wasn't competent substantial evidence of the damages. When the court reverses this case, it is reversed to the trial court without instructions, no instructions whatsoever. And so with that, upon remand, I file a motion to amend to the trial court saying I would like leave to file now a claim for fraud.
What case authority do you have that allows you to move to amend after you've had a trial?
Wells Fargo and a case from this court actually, Florida Air Conditioners Incorporated versus Colonial Supply Company. That case is at 390 Southern 2nd 174. I discuss it in the reply brief. In that case, what had happened was a plaintiff went all the way to judgment on a statutory claim.
By trial?
Pardon?
By trial?
But jury trial.
Okay.
Jury trial. The case went all the way to judgment, jury trial, came up on appeal. This court determined, and the first appeal, where statute was basis for judgment recovered in trial court, and first appeal decided only that statute was not in effect and did not govern debt in question, and that jury instruction on the statute thus prejudiced defendants. And first appeal did not hold that plaintiffs had no cause of action against individual defendants. This court did not make any determination to the effect that my clients had no cause of action. For debt aside from statute, amendment of complaint to state cause of action in debt would not be inconsistent with or repugnant to allegations in original complaint, would not entirely change or abandon nature of plaintiff's case as first presented, nor introduce new theory of recovery not theretofore asserted. And in furtherance of justice, plaintiffs having changed their position, relying on erroneous ruling of trial court, were to be returned to their position before such ruling.
Well, wasn't that case decided before the Supreme Court decided Dober or Archie-Fried?
Yes, it was, and it was also decided before the Supreme Court decided the Wells Fargo case. But I don't mean to be contrary, but yes, Your Honor, absolutely it was. And in the Dober and Archie-Fried cases, which I'm aware of, and those are instances in which parties were not allowed to go back and amend. But what's curious, if you look at Doby and Archie-Fried, and particularly if you look at their progeny that follow, inevitably what you'll find in each of these decisions is commentary, if not determinations by the appellate court, as to how a complaint is unamendable or can't be amended to begin with. Because what you find in the cases that, and more often than not, these are cases dealing with instructions from this court that specifically say, and by the way, thou shalt enter directed verdict, or thou shalt enter judgment for the defendants. Now, perhaps I'm being overly optimistic, but I construe this court, having remanded this court, or this matter to the trial court for further proceedings, to direct the court to include among that, should it be persuaded that there's a bona fide claim.
Why isn't this a classic case of trying to get two bites of the apple? You chose beginning to bring an unjust enrichment count. Presumably, you could have brought a fraud count in the alternative if you wanted to. You didn't do it. If you had gone to trial and lost on unjust enrichment and there had been no appeal, you couldn't have come back and moved to amend to bring fraud, right?
Perhaps so, but...
Why isn't this just trying to get a second bite then? You had your shot. You could bring whatever theories you want. you didn't bring that theory, and ultimately after appeal, you lost. Why do you get to start again?
Because Wells Fargo says if it's ultimately determined we failed to state a claim from the get-go, and there is a meritorious claim there to be had, then the equities require that my clients be an opportunity to have this matter decided on the merits. And while I'm loath to criticize a trial judge who, quite frankly, we were successful in front of, I guess the underpinnings of this argument is, to a certain extent, if you're going to rely upon the trial court's rulings in getting where you ultimately end, and it turns out those rulings are wrong, and specifically, as stated in Wells Fargo, it culminates in a determination that you failed to state a claim at all, then the analysis isn't so much law of the case as it is whether or not the case goes back as though you're now dealing with a complaint that just failed to state a cause of action.
Well, but the Wells Fargo case dealt with, I mean, the relying on a trial judge was an erroneous ruling of the trial judge. Your decision whether or not to bring a fraud claim didn't depend on any ruling of the trial court.
Well, here again, I'm loath to criticize a trial court before whom we were successful, but I guess you would argue, in the first place, these pleadings weren't challenged via motion to dismiss. They weren't challenged until a motion for summary judgment.
What we're talking about here is a claim you didn't bring.
Correct. Because we were succeeding on the claims that we did bring. And first off...
Oh, but no motion to dismiss was brought, so the trial court didn't erroneously say it stated a cause of action.
Correct. Not until it was challenged by motion for summary judgment. At that point, the issue was raised as to whether or not the benefits we conferred sufficed to sustain a claim for unjust enrichment. And at that point, the trial court denied their motion, said no. So my point is, we're going all the way up to trial, with the belief, if you will, that we have 3 viable counts here. I suppose, arguably, you could say, well, it should have occurred to you that you needed to throw a few more in. Here again, we're successfully proceeding on 3 counts. We go to judgment on 1. And it's not until we come to this court, with all due respect, that this court decides that we don't have a viable cause of action. And under the Wells Fargo authority, that basically puts us back in the posture, if you will, of having a determination to the effect that we have failed to state a cause of, our complaint fails to state a cause of action.
Had the parties in the Wells Fargo case proceeded to trial?
No, not in the Wells Fargo case. Wells Fargo was a default judgment, as I recall it, and when the default judgment was appealed, it was determined on appeal then that the underlying cause of action failed, and that's why that was set aside. But here again, the concept that Wells Fargo postures, if you will, is nothing new, and it's nothing new to this court, which is why I go back to all the way back to the Florida air conditioners case. And again, what I emphasize here is...
Well, that was the case where they remanded because there was an erroneous jury instruction, didn't they?
They remanded it because there was no claim to begin with, because the statute upon which the plaintiffs proceeded, where statute was basis for judgment recovered in trial, statute was not in effect and did not govern the debt in question. So the determination by the by the appellate court, was the very underpinnings of the claim were removed. Much as this one, when this court decides, well, what you alleged is insufficient, you failed to state a cause of action. And so with that, and coupled with the fact that this case is remanded, like I say, without instructions, and it then arrives at the trial court. The trial court is now confronted with a motion to dismiss. The trial court correctly states that there are 2 bodies of law that it's contending with. One of them being, and the court recites it in its opinion, the authorities cited by the plaintiffs make clear there are circumstances in which a party should be permitted to amend its pleadings even after an appellate court remands the cause to the trial court. See, for example, Wells Fargo, cites the very case that we're relying on. Goes on to say, as the plaintiffs acknowledged and emphasized, the allegations in the proposed amended complaint reflect a new theory of recovery. Take issue with that. I don't know if there's a new theory of recovery because the facts were alleged in the complaint. The facts were described by this court as an unpled theory when it came to the unjust.
If at the end of this trial, the trial court had come to the conclusion that we ultimately came to and had said, you lose, no cause of action, improper damages, etc., would the case have been done? Or would you have been able to move to amend and say, well, okay, now that you say that's not a cause of action, let me try something else?
I don't know that I would be permitted to amend at that point in time.
So why is it any different that it took us to decide that you didn't have a cause of action after trial as opposed to the trial court for you to be able to say, okay, then let me amend and try again?
Because we did go all the way through the trial court. We did go all the way through to conclusion with our trial judge. And it wasn't until it arrived at this court, everyone in that courtroom had the mindset, if you will, that there was an unjust enrichment claim to be pursued. It wasn't until we arrived at this court that this court said, no, you have no claim at all, and didn't reject it because of insufficient proof. Not talking about the damage part, talking about the liability part on the claim. Didn't reverse it because of insufficient proof, said you never had a claim to begin with. You can't hold these people, the benefits you conferred 10 years earlier to these people arriving on the scene are insufficient. And so the trial court, when presented with this case, or your appellate opinion, remanded in the way it was, I would respectfully submit, under Wells Fargo, was confronted with the task, if you will, of determining whether or not the plaintiffs had abused their right to amend, which it never even examined or explored, or whether the amended complaint would be sufficient, which it never even explored, and for that matter, did not even explore the argument I'm making here to the effect that this court determined that there was a failure to state a cause of action.
Your time's
I
expired.
know I'm over my time. Thank you very much.
Thank
I would
you.
respectfully request the trial court's order be reversed and the parties be allowed to proceed to have the matter determined on the merits. Thank you, Your Honors.
Good morning, Your Honors. I'm John Christie, along with Lester Caney, represent the appellees in this case. I think the court has a good grasp, obviously, of what the issue is in this case, and that is whether or not, as a matter of law, the appellants are entitled to amend their complaint post-verdict, post-judgment, and post-appeal in order to assert an entirely new cause of action which admittedly came to them during oral argument in the prior case, and I believe under questioning from Chief Judge Palmer. Chief Judge Palmer has characterized this case correctly. It's the proverbial second bite at the apple. The answer to that question I posed to the legal issue is a resounding no. The appellants have cited no authority, no legal authority, for the principle that a party who has thoroughly litigated the claims on the merits through trial and through verdict and through judgment and then appeal is now entitled to, after the fact, come back and replead and amend to assert a new cause of action because it lost on appeal.
Opposing counsel didn't discuss the Don Suntan case.
Well, I'm glad you brought that up, Your Honor, because I was going to argue that. I went back and looked at both decisions. There's the Don Suntan decision, which is from 1985, which was the appeal from the trial court's verdict, in which the trial court sent a question of contract interpretation to the jury, and this court reversed and then said the contract interpretation is a question of law and this is how it should be interpreted, and remanded the case, I might add. The judgment below was reversed and the cause remanded for further proceedings consistent with this opinion. On appeal, Mr. Volkelja, who happened to represent the plaintiff in that case, ironically enough, sought to amend his complaint to now advocate a cause of action based upon this court's interpretation of the contract. That motion to amend post-verdict, post-judgment, post-appeal was denied. He took an appeal of that order to this court, and the trial judge was affirmed. And this court wrote, "The general rule is that once an appeal has been taken, the decision on appeal becomes the law of the case, and on remand, amendments to the pleadings cannot be made to present new and different issues of fact or law unless the appellate court in its opinion has authorized such amendments." This court in its prior opinion did not do so. In fact, its opinion is remarkably identical as far as the direction to the trial court as in the first Don Suntan opinion, which is at 482 Southern 2nd 409 1986 decision. The trial judge, when he got the remand from this court, had but one choice, and that was to enter a directed verdict and judgment for American safety. That was the only decision and action the trial judge could have taken that would be consistent with this court's decision. I might add, if you look at this court's decision in the prior appeal in this case, what the court said is the Connecticut 7 did not establish that they provided a benefit directly to American safety, for which American safety had not paid, namely an evidentiary deficiency. Then the court went on to say, even if they had, the Connecticut 7 did not establish the value of the benefit allegedly conferred. Again, an evidentiary deficiency. So not only I would disagree with Mr. Volkel's interpretation of the court's opinion, and the court has found that they did state a claim, they did state a cause of action, simply didn't prove it. And even had they proven that cause of action, they did not prove their quantum of damages. And as a consequence, the judgment was reversed. And what American Safety is advocating is consistent with the precedent of the Supreme Court in the Archie case, in the Dober case, all cases that were litigated on the merits. Wells Fargo, that Mr. Volkel just cited, was not a case that was litigated on the merits. Cases where there are default judgments, cases that are based, for example, the Florida air conditioning case that he cites, which was reversed because of the applicability of a statute which barred the cause of action, which essentially the claim wasn't litigated on the merits, would give rise to a claim by a party that he or she should be able to amend their complaint because they didn't get their day in court. In this case, the appellants had their day in court. They had a trial, they had a judgment, and they were able to appeal it. It's important to note that there was no cross appeal. When American Safety appealed the judgment of the circuit court, which entered a judgment against American Safety, a monetary judgment, and the denial of its motion for directed verdict, there was no cross appeal. Mr. Volkel appealed nothing. This court specifically found that American Safety did not try any issues by implication. There was no request to amend made during the trial by Mr. Volkel of any sort. It's simply the classic second bite of the apple, and I want to say buyer's or seller's remorse, as the case may be. Your Honors, this case is with American Safety and Harbor Village, and Mr. McMurray and his associates has been in this court for almost 9 years, in the courts in Volusia County in this court for almost 9 years. There have been 5 times the case has appeared in this court. At some point in time, there has to come an end to litigation. What Mr. Volkel is advocating would result in a destruction of the finality principle. It would result in the expansion of endless and necessary costly litigation where appellants constantly say, well, I didn't prove my damages, I've been reversed on appeal, let me go back and prove damages. Or, gee whiz, I should have thought of that. Let me go back now and amend my complaint, post-verdict, post-judgment, post-appeal, because I learned something in oral argument. If that were the law, then litigation would never end. That is not the law. It's not the law of this court. It's not the law of Florida precedent from the Supreme Court. The trial court's order denying the appellants one more bite at the apple and granting American Safety directed verdict is consistent with this court's prior decisions and established Florida Supreme Court precedent and should be affirmed. Unless the court has any questions, I'd waive the balance of my time.
Thank you, Counsel.